Law for Life, the podcast, with Franklin Solicitors.
Hello and welcome to another episode of Law for Life, the Franklin's podcast. Great to be joined again by Eddie Bell from Franklin's. Hello.
Thanks, Chris. Great to be here back again. Yeah,
great to have you here. And I think today we're going to be talking about something that's incredibly important. It's been in the news recently, and it's something that I think it's really worth giving a good overview of, and that is lasting power of attorneys, or lasting powers of attorney. I'm not sure which one. Lasting power of attorney is the subject, and we're going to find out what it is, why it's important to have one, why it's something that we should all be considering at different points in our life, and maybe it's something that if you've got older relatives you need to talk to them about, because it's something that probably they should be thinking about. But to get started, could you give me a quick summary of what a lasting power of attorney is?
So a lasting power of attorney, or an LPA, is a document in which somebody, the donor, can appoint attorneys to act for them if they, for instance, have lost capacity or they start to struggle a bit with decision making. And there are two different types. There's one for property and financial affairs, and there's one for health and welfare decisions.
Okay, so they're different, because I thought it was just a case of you sign one of those and then you've given the power to somebody else, whatever might come along the way, but they're two different distinct areas.
Yeah, two different documents. Most people will just appoint the same people as their attorneys for both property and for health. There's nothing to say that you have to do that, and also nothing to say that you have to have both types. It always used to be that most people would go for property but not for health, but in recent years I've been seeing a lot more people who want to do both and just cover all bases, because really, a lasting power of attorney is there. It's kind of like a rainy day policy. It's there just in case something happens, because you might. Often people will think of it in terms of, what happens if I get dementia and I need somebody to act for me if I can't make decisions anymore. But it's not just for that. It could be if you're unfortunately in some kind of accident and you've lost mental capacity as a result of that, or you end up in hospital and you don't yourself have the ability to do something. It's always handy to have attorneys there on hand, people that you trust completely, to help you make as many of your own decisions as you can.
Because as you say, this could happen to you at any age, because you never know when horrible circumstance might mean that this is necessary. So what are the differences between the property one and the health one? What different things would they be used for?
Well, the property one would cover things like investment decisions. It could be deciding whether to sell your house. It could be whether to open a new bank account or move money between different accounts. Whereas the health one is more about things like whether you should move into a care home or not. It could be whether you need to have some kind of operation. Or in the worst case, it could be a question that somebody has about. There could be a question about whether a decision needs to be made about keeping you on some kind of life-sustaining treatment. And in that case, you'd need to say whether you're happy for the attorneys to make that call, or whether you want it just to leave it up to the doctors.
I think that's really useful to know, because I think maybe some people might be hesitant to create an LPA because they'll think, I want this so that somebody can look after my financial affairs if I'm not able to, but I don't want them putting me in a care home or switching off my life support because I'm becoming a financial burden or something like that.
Exactly, and that's why it's so important to choose attorneys that you trust completely. And it's also important to remember what an LPA is for. Some people think that it's about them appointing somebody who can tell them what they can and can't do. I once heard of a case where an attorney said to their donor, "I'm your attorney, that means I'm like your bank manager, I'm your manager. If you want something, you need to come to me." Which is not really what they're for. They're all about making sure that you have as much power to make your own decisions as possible. If you're struggling, your attorneys can help you make your own decisions, and they only can step in and actually make them for you if they've tried helping you but they haven't been able to.
Okay, and if your mental capacity is okay, then they can't do anything without your permission.
Well, they always have to act in your best interests, and this comes into a question about the property LPA, because in that one you get a choice about when your attorneys can start using it. You can either say they can use it as soon as it's been registered at the Office of the Public Guardian, which can be even while you still have capacity, or it can only be once you've lost capacity. And generally it's better to go for the first one just because it's more flexible, because it might not be clear whether you've got capacity or not, and you don't want necessarily to have to waste time going to a doctor to find out if you've got capacity. And it's also useful if you're physically incapacitated but you're mentally fine, because in that case you can just say to your attorneys, oh, can you go and do this thing at the bank for me as my attorney?
Okay. Which is really handy if you're, stuck in a hospital bed because you've broken all of your legs and you can't get there, but actually you're mentally absolutely fine. But I think it's a really interesting one, because it's not always black and white whether you've got capacity or not. And certainly with types of dementia, sometimes you have good days and bad days, and there might not be a single day where you say, right, suddenly now that person doesn't have capacity. Is there an official medical way of determining when that moment comes?
Well, the legal test for whether you've got capacity is if you're unable to make a decision because of some kind of imbalance in your mind or some kind of medical condition. So you have to show that the inability to make the decision is linked to the underlying medical condition. And as you say, just because you're diagnosed with dementia, for instance, doesn't necessarily mean that you've completely lost capacity. As you say, you might have good days and bad days, or you might be able to make some decisions but not others. So the question's always, do you have capacity at this particular time to make this particular decision?
Okay. So it's not necessarily that it would kick in and then that would be permanent. It might be necessary at a particular moment, and then the next day you might not need to use it.
Yeah, exactly. And there's also the presumption that you have capacity unless it's established that you don't. And in practice, that would be done by some kind of medical professional.
Okay, interesting. Now, I mentioned earlier that this has been in the news recently, and Martin Lewis, the money-saving expert, has been saying that, in his opinion, LPAs are more important than wills. Is that something that you'd agree with?
Well, they're both important, but I wouldn't say one's more important than the other. It's like saying that shoes are more important than shirts. They just do different jobs, and if you really want to protect yourself, you really need both.
I would say in your line of work, it's probably good to be taken seriously if you're wearing shoes and a shirt. Yeah. Okay, good. So, can anybody be an attorney? Does it have to be somebody in the family, or what are the rules on who you can appoint?
Well, it just has to be somebody who's 18 or over and that you trust completely, because you're giving them a huge amount of control over your finances or your health. You can't, for the property LPA, appoint somebody who's bankrupt. Okay. So you'd need to just check with them that they haven't become bankrupt. If
they've been bankrupt at any point in the past or currently?
I think it would depend on the situation in question, and if that's a concern, then we can always chat through things with you.
Okay.
But the main thing is you wouldn't want somebody who is bankrupt looking after somebody else's finances, because the idea is that if they've become bankrupt themselves, then maybe they aren't the best person to be doing financial work. If you've also, something to think about is if you've appointed your spouse and then you divorce, their appointment as attorney ends automatically unless the LPA says that it carries on even after we've divorced. So that's something to bear in mind if you made LPAs a while ago and you've since become divorced. It's definitely worth reviewing things just to make sure that they still work as they should do.
If you haven't cancelled an LPA and you get divorced and you haven't got around to it, and then something happens and you no longer have capacity, I guess there's nothing you can do. It's legally binding.
Well, it depends if there are any other attorneys, because you might have appointed somebody alongside your spouse, and depending on how that's set up, that other attorney can just take over. Or it might be that you've appointed a replacement attorney who could then, in theory, step in. Because there are a few different ways that you can appoint attorneys, if you've got a few different people in mind. One idea is to have one attorney and a replacement, and the replacement would only step in and act if something happens to your first choice attorney.
Okay.
Like if they've died or they've lost capacity themselves.
Which is possible because it might be an accident that you're both involved in, and then, you know, the person that you were going to rely on in that situation is also incapacitated.
Yeah, exactly. And another way to do it could be to have multiple attorneys or all acting together. And if you go for that way, there are two ways that you can appoint them. You can appoint them either jointly or jointly and severally. So jointly means that everybody signs off on everything together. They all have to act unanimously. And if, in that case, one of your attorneys dies or loses capacity, the whole thing falls apart and you have to make a new LPA.
Can you not put it in the terms that jointly and severally unless one of them's dead?
I would always say just appoint them jointly and severally to begin with, because that way is the most flexible. It means that any one or more of your attorneys can go off and act on your behalf without needing to get everybody to sign off. And that's particularly useful if, say, one of them's up the other end of the country or they're abroad, for instance. Yeah. Some people also might want to think about appointing attorneys jointly for some decisions, but jointly and severally for others. So occasionally you see LPAs that say, my attorneys have to act jointly when they're selling my house, but can act jointly and severally for everything else. But that really leaves you in the same predicament as just appointing them jointly to begin with. And if the concern is, I don't trust one of my attorneys to act in my best interests, then maybe think about appointing somebody else to begin with.
Yeah, absolutely. But I think you never... I think if you were in this situation, sometimes you might think, who can I really trust? And you don't necessarily always know, you know, how relationships might pan out over a long period of time. And maybe it is good to have backup plans in place. So what's the process of appointing an attorney? How do you go about doing that?
Well, if you come to Franklin's, i.e. the best firm to do your last power of attorney, we will go through your family situation with you, and we'll ask what sorts of people you'd like to appoint. We can prepare the documents for you to set out your details, the details of your attorneys. You then sign the LPAs as the donor, so the person making them. Then usually a solicitor will sign as your certificate provider to confirm that they're happy that you understand what you're doing and that you're not being coerced into it by anybody. Then your attorneys would sign, and then once everybody's signed, the LPAs are sent off to the Office of the Public Guardian to be registered, and they charge a registration fee of £92 per LPA. And then we're really just in the hands of however long the OPG take to process the registration at their end. It's typically about 10 to 15 weeks. And then
okay, so it's quite a long time, actually.
It can be, yes. It's meant to be 4 weeks, but it's always been a case of the OPG working to a backlog. Because when LPAs were introduced in 2007, they came in with the requirement that before they can even be used, they had to be registered. And I don't think the OPG realised how many people would want to register them straight away.
That's really interesting, because I think sometimes if you have left it to the last minute and there's a situation where you think, I need a power of attorney, let's get somebody appointed, you might not realise it's going to take maybe up to 4 months before anything can be done. So, yeah.
Yeah, exactly.
Okay. And can an attorney intervene if you're a donor and you do something unwise?
Well, the legislation says that you can't treat somebody as lacking capacity just because they make an unwise decision. So you could put your whole life savings on the Cubs winning the World Series, but then that by itself doesn't necessarily mean that you've lost capacity. It might show that capacity is a bit of an issue, and depending on how the property LPA is set up, your attorneys might already have the power to act for you anyway. It's just that they always have to make sure that they're doing it in your best interests, and they're not overstepping the mark. Okay,
so in this sense, because I was just reading that question, I wasn't sure what donor meant, but I've just realised donor is the person that's
making the LPA. They're giving the power of attorney to their attorneys.
Okay, so that's useful to know some of this jargon if you're if you're using these. And if you fall out with the other person, so if the donor and the attorney fall out with each other, can they be changed or revoked at that point?
Yes, you can revoke an LPA at any time while you still got the mental capacity to do that. You would need to execute what's called a deed of revocation, and then you would need to send it to your attorneys to tell them, you're not my attorney anymore. And that's usually used when somebody's making a new LPA, because making a new LPA doesn't automatically revoke their existing one. Usually what we would do is, if somebody already has a lasting power of attorney and they want to make a new one, we make the new one, send it off for registration, sign the deed of revocation, but leave the date blank until we know when the new one's going to be registered. So that way there's something in place to tide you over until the new one's registered.
Yeah, that is important, especially if it does take a few months, as we were saying.
Yeah.
And I guess if you've lost capacity and at that point you decide that you changed your mind about who your attorney is, there's nothing you can do. Is there a way of trying to prove that you still have capacity and they're saying that you don't?
Well, the presumption is that you have capacity unless it's established that you don't. It may well end up going to the Court of Protection for them to hear whether you do have capacity or not and whether your attorney can act. I mean, if you don't have an LPA in place at all and you've lost capacity, then somebody would have to apply to the Court of Protection to become your deputy, which essentially gives them the same powers as an attorney would have, but it's a much longer process, it's a much more expensive process, and there's a lot more oversight from the court and from the OPG. For instance, you have to file accounts with them every year, which you don't have to do as an attorney. So best to do an LPA while you still have capacity.
Yeah. So if you have a loved one who's in that situation where they're losing capacity and you've suggested to them that an LPA is probably a good idea and they're refusing, there's no way of forcing them to do that, is there? Well,
again, that comes back to, you can't treat somebody as lacking capacity just because they make an unwise decision. It may be very wise for them to make an LPA, but if they are adamant that they don't want to, then that's their decision. If then they've lost capacity later, then somebody would need to apply to become their deputy.
Okay. And just because maybe you've been diagnosed with dementia doesn't mean that you don't have capacity at that point, does it? Because as you were saying, it depends on a medical assessment and how far along you are with the condition.
Exactly, and yeah, things like dementia, your capacity will fluctuate, so you will have good days and bad days, at least at an early diagnosis. So just because you've been diagnosed doesn't mean that it's just a red line in the sand and that there's nothing you can do at all.
Okay, and can an attorney tell the donor what they can and can't do?
Well, again, it comes back to the attorneys are there to help the donor make as many of their own decisions as they can. They're not there to be like the bank manager. They're really there to empower the donor, so the person who made the LPA, to do as much as possible themselves.
Okay, but if they want to give them some advice, that's not frowned upon. Maybe they're just sat on the side of the hospital bed saying, I really think we should do this. Is it okay if I go to the bank and sort this out? Is that all right? And you kind of encourage them to do something?
Exactly, just so long as you're acting in the best interests of the donor. And that's not necessarily the same as what the donor would do themselves in that situation.
Okay, so it's what you in your capacity as the attorney think is in their best interests.
Yes, and it might come to a point where maybe a decision needs to be made about social care. So maybe at some point adult social services will be involved. They might suggest setting up some kind of best interests meeting where everybody can get round the table and actually work out what's best for this person, and then as attorneys you can go off and then do that.
Okay, so what about this situation where maybe you've got a family member or a loved one who's appointed somebody else as their attorney, and you, as a caring relative or friend, don't think they're acting in the best interests of the donor? Can you do anything to challenge that?
Well, that would be That would be more for a litigation solicitor to speak about more than me. Certainly, there are things that you can do at the Court of Protection, and I'm sure our litigation team would be happy to discuss things further.
Okay, so don't just accept the situation. It's always worth getting legal advice and seeing seeing where you stand.
Yes.
Okay, cool. Well, hopefully that's given you a broad overview of LPAs, and it is a complicated matter, but it's something that is very important, as are wills and other things that we've also talked about on other podcasts. But as we always say, the best thing to do is to get personal legal advice from a solicitor such as the experts here at Franklin's, and you can guide both parties through that process, and better to do it sooner rather than later, because you never know what's in store, do you?
Absolutely right, yeah.
Okay, brilliant. Well, thank you very much for your time, Eddie. And if you'd like to talk to Eddie, and get in touch with him at Franklin Solicitors. Thank you.
Thanks very much.